Hello and a very good afternoon to everyone. Hope you all have had a great start to the new year. My name is Anisha Chand and I'm a partner with the competition and antitrust practice at Khaitan & Co. I will be your moderator for today's discussion and I will also share some snippets in between while the speakers discuss their respective segments. It is my pleasure to extend a very warm welcome to all the audience for this uh, 2025 edition of our annual competition law wrap up. Those of you who are our regular participants and regular attendees already know that we do this wrap up as an annual ritual now. Those who are attending for the first time, welcome aboard, and we do hope that you find all the reasons to keep returning to our wrap up series year on year. The annual wrap up, as you can guess, is designed to reflect upon the various developments and trends in the Indian competition antitrust space in the year gone by, with the intent to really foreshadow what the future has in store. And our attendees have usually found the roundout to be a very useful recap of all the significant developments which are distilled into a singular session that also motivates us to keep bringing this back to you year on year. In terms of certain hygiene protocols and questioning, we've already received a few questions from the attendees. But if you do have questions, please put your questions in the chat box and we'll be delighted to answer them live. If we cannot cover all the questions during the webinar, we will email you the responses for sure. And like all our webinars, a copy of the presentation and the recording will be shared with you as a matter of course. With that, I would like to introduce our esteemed speakers, who are also my brilliant and extraordinary colleagues and partners. If you can just go to the next slide. We have got Manas Chaudhary, Pranjal Prateek, and Anshuman Sakle. And each of these speakers will be providing you insights on different aspects of our agenda today. So we will be very quickly covering, if you can just go to the next agenda slide, please. We will be covering the whole gamut of key developments across policy and legislation and behavioral as well as merger control activity that we have witnessed in the year gone by. And finally, we will also crystal ball gaze into what the outlook for 2025 looks like. So with that, I invite our first speaker, Manas, who will be taking us through certain legislative overhauls, including a few policy initiatives that the Commission has been driving. Next slide, please. And Manas, over to you.
Thank you, Anisha. And it would be a pleasure once again coming back to one of our most favorite topics, the wrap up. So, what I'll start off with is the scope of 2024, what has happened in this last 1 year. So, as all of us know, that on 11th of April 2023, the Competition Act got the assent of the President and became comprehensively amended from what we had prior to that. Why I say comprehensively amended? Because there are many interesting changes being introduced by the Parliament, which actually is going to change the landscape of Competition Act going forward, especially for the clients as well as, of course, for the authority. So one of the major changes which I thought was likely to impact us can be divided very well between the two limbs of the Competition Act. One is the antitrust and the other is the merger control. My other colleague partners would be taking you through to those slides in the later part of our presentation. I would just like to focus something relating to, say, for example, what were the focus of the legislative changes. Most of the legislative changes were trying to, meet the gap which the CCI and the Appellate Tribunal and maybe in some cases before the Supreme Court. The government found that there were certain gaps which needed to be filled in, enabling the law to be made more holistic insofar as the stakeholders are concerned. That is one area I think was the intent of these amendments. They did bring in certain very interesting changes in the antitrust enforcement, which is with an aim to expedite the waiting period in terms of getting the final orders and minimizing the process of litigation. So when I say minimizing the process of litigation, I typically mean that minimizing the waiting period in appeals. So in that regard, the two limbs have been added in the vertical restraint part and abuse of dominance, which are typically called in our law commitment and settlement. So with the commitment and the settlement, which has been introduced in the law by way of an amendment, it is yet to be, of course, seen, because we don't think that there are any cases as of now of these two newer limbs, because the whole of 24, the CCI and the Government of India were busy in drafting the regulations in order to make the enforcement predictable. So we are still to see how this commitment and settlement really pan out. But these are two very interesting changes, and these changes will be discussed in detail by my other co-panelists in the subsequent slides. So in case of merger control, the changes which are, of course, the typical Section 5 thresholds being revised upwards, which has been a very usual act of the CCI and the Ministry of Corporate Affairs, because there is a provision, enabling provision available in the law itself, that every after 2 years they can really go in for an upward revision of the thresholds, which is of course being revised here also. The interesting part which has been added in the merger control by way of an amendment, that the government and the parliament have decided to introduce a minimum deal value threshold, which typically means the transactional value between the parties, which should be another area of a mandatory threshold which the parties need to really look at before they really go ahead seeking for some exemptions. Because until the time the deal value threshold was not there, there was very easy to get exemption by way of a small target exemption, which has definitely been plugged in terms of the thresholds being introduced by way of a deal value. That would also be discussed in a greater details. And the last point in my slide is the introduction of the Digital Competition Bill. As we all know that the government and various stakeholders were contemplating to discuss, and ultimately they have decided to have a policy, which the Parliamentary Standing Committee had also taken it up seriously. And in March of 2024, pursuant to these discussions of the Digital Competition Bill, the bill has been placed in the public domain for the consultation of stakeholders. As on today, it is still under consultation process, and the bill has not yet seen the light of the day by way of new legislation. But that digital competition bill is very much in the public domain, and there are stakeholders who are still deliberating as to what are the changes still can be thought of. Because ultimately, this digital competition bill will, in my view, will be a subset of the Competition Act, because the enforcing authority both for the Competition Act and the Digital Competition Act, whenever it is enacted, will be the same, that is the CCI. They may have a different investigative wing, which can be the Digital Markets Unit, but the total enactment process and the procedure of the Digital Competition Bill would be completely governed by the Competition Act and the management of the Competition Act, that is the CCI. Can you go to the next slide? So in 2024, what policy focus the CCI had really helped us analyzing for today's webinar. In the month of January, the CCI initiated a sector study, which is part of their competition advocacy mandate, and all of us know that from the time the CCI has been constituted, there had been lots of market study reports which are being uh, which have engaged the attention of CCI, and they have come up with a lot of these kinds of market study reports. And in January of 2024, we saw that the impact of artificial intelligence was considered to be an area for market study, because as we all know that with the changes in the law, I mean by way of an amendment which is now part of the substantive law, this becomes very important because CCI is sector agnostic, and as on today, no constitutional court has ever allowed the challenges in relation to jurisdiction of CCI with regard to the digital enterprises. So naturally, CCI is already empowered, but at the same time, with the market study being taken up in January, it gives us a lot of food for thought. In March and April of 2024, they started talking about fintech entities to assess technology in being leveraged to affect competition. Now, fintech is also a kind of part of the entire digital ecosystem. We think of the startups, we think of these kinds of digital ecosystem in India, and in comparison to many of the jurisdictions, the Indian startup ecosystem is way ahead. And as uh, late as last month, I came to know from some international conferences that India represents almost 25% of the global startup ecosystem. So naturally, the CCI also interested to understand as to how it is going to impact, or maybe it is going to promote competition either way. So they also thought that this could be also an area of understanding for the stakeholders. Let's come to May. In the month of May, the CCI, of course, wanted to understand whether or not there are algorithm collusions, which is, of course, quite logical. The moment we talk about collusions, we only talk about when competitors are together, they are thinking about something which may, as per their strategies, may not directly impact a particular enterprise involved in that algorithm collusion. But if the software has been developed in tacit collusion of the parties to the beneficiary, the algorithm collusion can really become a competition law issue. And to my mind, that may be one of the areas with the CCI keeping in view and the uh, progress of the digital competition bill, that could be another area where the CCI too would get engaged itself into. So that is another area which we all saw in the month of May. This was discussed. And lastly, in the month of November and December, we found that the deal value threshold was being considered whether or not it can be causing some kind of a challenge towards the creeping acquisition or killer acquisition. But the issue of deal value threshold, to my mind, initially when it came into being for discussion, we all thought that perhaps the combinations of the big tech companies like WhatsApp, Meta, WhatsApp, Facebook, that could not be even considered for an assessment by the CCI because of the small target exemption being available at that point in time. And these companies did not have any assets. So, on the ground of assets being not there, they could get away even with the turnover being extraordinarily high. So, in order to really stop those mergers going out of the radar of the CCI, the deal value threshold became very important, and the government and the parliament both agreed with the suggestions from time to time was given to the government, and the deal value threshold became now a part of substantive law under the Competition Act. I stop here, Anisha. If you have got anything beyond these two slides, you can always ask me because I'll be then trying to answer them as it is possible in this limited time because we have got so many other slides also there.
Yes, no, thank you, Manas. I think that was very helpful. Again, legislative changes and regulatory changes were something that ruled the roost last year, and I think the efficacy of those rules and regulations is going to be tested in that sense. And AI, of course, is touching all our lives. The entire world is struggling to see how we can create responsible AI. But so there is one question that has come, which is not specifically on the topic that you've sort of covered, but I think you're best placed to answer this. And this question came from the audience at the time of registration, so I'm going to pose this to you. It is on invocation of writ jurisdictions in CCI proceedings, and the question, let me read it to you. The question is that what are your views on continued invocation of writ jurisdiction by parties even after 14 years of CCI's inception of enforcement actions, and how do you think that it impact case lines? What do you think is the future of these writs?
That's a very good question. The whole issue is that we have to also go a little deep into the Competition Act and the essence of couple of sections which I am trying to highlight. One is Section 60 and Section 61. Competition Commission is the exclusive competition related authority in disregard to civil courts in India. So naturally, no courts, even high courts and supreme courts, do not have original jurisdiction with regard to the competition issues. However, since Competition Commission and the DG office both are states under Article 12 of the Constitution, the parties, if they are agreed by the principles of natural justice or due process breaches by state, when I'm saying state, I'm talking about CCI and DG, they would not have been debarred from proceeding to the constitutional courts under 226, 227 of the Constitution and challenging the action of the DG and the CCI, which is nothing to do with competition law, but that is same. For example, I am asking for a cross examination, and the CCI and the DG either are silent or have rejected. Then where do I go? Because this is not an appealable order. In NCLAT, you can go only for the available order which are available under Section 53B. So if you do not have a remedy, then obviously the constitutional courts would step in. Now, the question arises in the last 14, 15 years, why have so many writs had happened? It has all happened because of some kinds of, I am very open to saying that the authorities keep on changing. insofar as the DG office is concerned, it is an institutional memory loss. So if one is not having that bandwidth to understand how damaging it can be if a authority is misreading the law in a manner which is actually a breach of due process or principle of natural justice, the party who is aggrieved will definitely ventilate its grievances in some or the other form, and here it is the writ courts. How can we remedy? There has to be a continuous legal training of the people who are issuing these orders, which are non-appealable, yet they impact an aggrieved party. They should minimize this opportunity of parties going to the writ, because once a party files a writ, the high courts have jurisdiction to reject it at the threshold. If they are not rejecting at the threshold, it means the high courts are convinced that the writ jurisdiction of this aggrieved party lies before the high court. And once the writ has been admitted, then the whole process of investigation gets derailed. And in the process, the confidence of the authority in the eyes of the stakeholders keep diminishing. That is what the CCI will have to protect itself. The DG will have to protect itself. It is not that the parties are just doing it for fun. Because if there is a writ which is frivolous, I am sure that it would be dismissed. It would be dismissed maybe at the threshold. So I think the course correction is inherent within the authority because it is the state. It has to be extra careful about implementing the law. Since the parliament has given the statutory powers to both the CCI and the DG to be exclusive, but at the same time, the law says it's dependent upon principles of natural justice. So if you are not following the principle of natural justice, obviously the party aggrieved who are likely to face huge financial penalties besides reputational loss would not be lying low not to agitate it before high courts. So that is my answer to this question.
Well, that's a brilliant answer, very wholesome. And with that, I'm going to just move to the next slide. But just a remark in continuation with what Manas said, we have seen, the point on continuous legal training. It seems like after so many years, there are much fewer orders of the commission which are getting set aside on principles of natural justice lapses. So in that same sense, I believe that there has been some level of learning at the commission, which is why there are lesser orders which are getting either remanded or set aside for due process issues. But if you can just move to the next slide. What we have on the next slide, which on that note, makes a good segue before I hand over to Pranjal, is basically a snapshot of the enforcement activity. And what we have here is some statistics which will tell its own story. So compared to previous years, like we just heard, CSA's focus has been more towards getting these complementary regulations, supporting the main legislation in place to implement the amendments. So that could be one of the reasons where the overall behavioral enforcement activity has been comparatively lesser. But if you just look at the numbers, we've got fresh investigations ordered in 11 cases, which is a reasonable number, and contrast that with the number of cases which at the threshold were disposed of. It is 36. And again, one trivia here to note perhaps is that the number of investigations are just 11, potentially because we as practicing lawyers also feel that the commission has a much more sharper focus, or when it's looking at cases at threshold itself, it's looking at cases with a sharper lens to evaluate if these cases are even worth being investigated by the Director General. Now, if you look at it narrowly, in the number of cartel cases where penalties have been imposed, there are none in 2024, but there have been 4 dominance cases where penalties have been imposed. The biggest one, of course, is the fine on Meta, which was a large fine for one of its privacy policy updates. It was found to be an abuse of dominance issue. At the appellate court, I would say that the CCI has had a good run. Most of its orders on merits have been upheld and affirmed. There have been trimming of penalties, so the penalties have reduced in some of those cases. But largely, the NCLAT has, or the appellate tribunal has, confirmed the commission's orders. And generally, if you look at the themes or particular sectors where CCI has focused more, I'd say that tech remains very, very hot. Alcobev also continues to be buzzing with a lot of activity. and sports federations also, that momentum has been sort of steady. It's periodic, but it seems that more and more cases in different sports federations from abuse of dominance perspective have been put before the commission. So this is what the enforcement activity snapshot looks like. If you can just move to the next slide. I'm going to now invite Pranjal to walk us through some of the key legislative changes that Manas alluded to. What are the range of regulations that have also come into place to really operationalize all of these, sort of amendments that have come into place in the Competition Act, and what you think the impact is going to be of these changes going forward. Pranjal.
Thanks, Anisha. And I think the previous slide, the snapshot of what has happened on the enforcement side, I think that brings a good segue to this slide and perhaps explain some of the things that we have noticed there. And as you, Anisha, you rightly pointed out, in fact, it looks like the enforcement activity has been somewhat slower than we anticipated on account of some of these legislative changes. So in 2024, what essentially happened was, I would say, culmination of all the legislative changes that the ministry and the CCI was bringing over a period of 2-3 years, and finally in 2024, all of those have been ironed out. All those regulatory legislations have been put in place. All of them are in effect, and now the Competition Act as amended is in complete effect. So and we are hoping that with this year onwards, we will see CCI much more proactive in various sectors. So I want to take you through some of the key highlights from the legislative amendments that CCI has brought in the last year. So the first one that you see on the screen on interlocutory and other applications. So this is a important one because in the past, for the last 10-12 years, we've seen that parties are at liberty to introduce new applications at any stage of the litigation, and then and that can really throw the CCI off radar, and the complete proceedings can sort of get a little bit derailed. And I think the idea here to introduce such a provision is to make sure that there is a little bit of a element of fee involved in all of the applications that CCI keep on receiving with respect to a case, so that these applications are actually are actually meant to be filed and are important for parties to file, and more importantly for commission to spend time on. So now interlocutory and miscellaneous applications can be filed, of course, but subject to payment of a certain fee, and those fees are not insignificant. So there is likelihood that we will see more streamlined applications, procedurally the cases not being derailed to the extent that we saw in some occasions in the past. So it's in the line of what CCI suggested when it was making these regulation changes, that these are designed to sort of ease the process of the entire proceedings and perhaps also shorten timelines. The next one I would want to discuss here on the monitoring agencies for commitment and settlement. I will come to commitment and settlements a little bit later perhaps, but one of the important highlight of the provisions relating to these aspects, commitment and settlement, is that now CCI can appoint monitoring agency even with respect to commitment and settlement cases. This was important because in many occasions commitment and settlement are future looking. You come up with certain remedies or self-imposed restraints in your business practices, which are very difficult, which could be very difficult for CCI to monitor itself. And CCI may not be able to rely completely on parties' own compliance reports. In such occasions, it is important that you have a third party monitoring those activities, and so we have this added nuance of monitoring agency, although this might complicate the process of applying for commitment settlement, which we'll come to a little later. But that's one other key change which can have implications in overall parties seeking route of commitments and settlements. Another important change has been that now the Director General, whenever he deposes a particular individual, in a proceeding, uh, that individual must now be also allowed to be cross-examined by the Director General itself. So how the process previously ran was, Director General would depose relevant individuals from different entities, relevant to the case, and ultimately submit its recommendation in its report. Then the CCI would CCI would give parties opportunity to comment on the report, and that is when many a times parties would first discover that there have been certain statements, certain oral statements made, which could perhaps have a bearing on the case or could affect their position in the case, and that is when parties rushed to again apply for cross-examination. And there have been some spate of litigation also involving cross-examinations in the past, where given the belated stage, CCI would not allow cross-examination and would require parties to submit any additional information by way of an affidavit. But those have been challenged in the writ courts previously, and writ courts have also highlighted the importance of the right to cross-examine witnesses. So keeping in line with the litigation, the time consuming the process, now the regulation has streamlined the entire sort of sequence of events. And now at the DG stage, and when the case is still under investigation, DG can then offer cross-examination of witnesses it has deposed. So that's a welcome change in that sense. Then also on confidentiality, we have seen lots of movement in the past couple of years on confidentiality. Many of you would be aware now, Commission has something called the confidentiality ring, where parties from the informant as well as the defending parties, they could get access to all confidential records, subject to a limited number of people being identified and sort of put in a ring, and then they could access those files and at least have a full confidence that they have seen all records, and especially the defending parties having the confidence that they know the case that they are asked to meet. So from that perspective, there were, again, with the confidentiality ring procedure in place, we were seeing certain problems. We had issues where confidentiality ring applications were made very belatedly, perhaps even after the final hearings were concluded, and that would really completely upset the entire entire proceeding and the timelines. So now the regulations clarify that there is a very short window within which one can apply for formation of a confidentiality ring after the DG report has been filed by the Director General. So that will go a long way in ensuring that the entire timeline of or a life cycle of a case is not completely sort of messed up. So and then lastly, the point that I would want to discuss is on the leniency front. So on leniency, as you might be aware, we have been speaking about this for a couple of years now. Leniency plus regime has been introduced by the Commission, and this is essentially to incentivize applicants who might not be who might have who might think that they have missed the bus with respect to the particular conduct in question, but they might have something else to offer with respect to a conduct in a, for example, in a neighboring market, or in a second product line that they are into. Very often we do see that, and we have examples from our own country where there were separate cartels in neighboring markets, essentially including the same participants. So for those kind of cases, the change in the law really incentivizes the parties to opt for leniency plus, which also bolsters their position in the first cartel itself, where they can get up to 30% of additional reduction, in addition to the reduction of up to 100% that they can get in the additional cartel that they have disclosed. Next slide, please. Yeah. The other aspect that I wanted to discuss, and we have taken a complete whole slide on this. This is on penalties. This is very important because while generally people are aware that the penalty regime has been overhauled and now there is a penalty guideline that CCI has to follow, but when you look at it deeper, that's when you understand the nuances, and perhaps some of the audience might be surprised to see the impact that these guidelines have now. So first of all, I would like to highlight that the penalties previously, after the Excel crop decision, could have only been up to 10% of the relevant turnover of an entity with respect to any infringement. Now that has completely changed, and with the guidelines in place, the CCI can impose up to 30% of the 30% of the average relevant turnover as penalties. And this change is massive because it could have an impact up to 3 times additional penalties on parties which perhaps may not have gotten the kind of attention which it should have. But obviously, this is subject to a maximum or statutory limit of 10% of the average turnover that the law prescribes. But nonetheless, in terms of relevant turnover itself, the penalties could go up to 30%. So that's something to keep in mind. And not only the penalty guidelines now state that the company will be liable if the company, for example, for some reason goes through certain corporate changes, the penalties could be recovered also from legal heirs. So that's also something relevant, and that is also relevant from an individual's perspective, where legal heirs of individuals could be made liable for the penalties imposed. The penalty guidelines also have come up with a host of factors that CCI will look into while coming into that determination of appropriate penalty. But and those are the usual factors as one would have sort of anticipated. CCI will look into factors such as duration, parties' role in the particular case, whether they had specifically certain limited role in the conduct that the CCI is investigating, whether it's a case of a repeat offense recidivism, what was the extent of cooperation with the DG and the CCI, whether there was a compliance program in place. So these are the typical factors that are relevant in any case while imposing penalties, and now they have been spelled out by the Commission. And lastly, if the relevant turnover is unavailable in a particular case, because as I mentioned previously, CCI will come up to a base amount for penalty, which could be 30% of up to a 30% of average relevant turnover. And where the party fails to provide relevant turnover, the guidelines are very clear that CCI can look at the global turnover itself. My sense and our team's sense is that the CCI is unlikely to go and look at imposing penalty on global turnover, generally speaking. But you know, there could be circumstances where party is not very forthcoming with data on their relevant turnover numbers. In that event, at least CCI has reserved itself with the power of going up to the global turnover. Next slide, please. Yeah. So very quickly, I'm on the last segment of changes to enforcement, commitment regime and settlement regime. Those both of these run, pretty similarly in terms of timelines and approach. However, one important difference is, of course, that commitment regime applies to cases where the DG report has not been issued, and only the prima facie case has been made by the CCI. So parties have an option to apply for a commitment within 45 days of CCI's prima facie order. And of course, such application can also be withdrawn by a party. In terms of its impact, as have been discussed previously in our webinars, that commitment regime does not involve any payout. A party under the commitment regime will have to come up with certain commitments in terms of its conduct on the market, which are designed to address the market harm. And as I mentioned previously, there can be a monitoring agency appointed to look into its implementation. And as far as regards the party which has filed for commitment, there will be a suspension of the inquiry. Whilst if there are other parties involved, the inquiry might just continue against them. And there is scope for parties, for the DG and the CCI to comment. CCI can ask public to also comment on the commitment offered by the party, and eventually decide on what is an appropriate commitment. One important point here is that there will not be any follow-on damages action which can be filed by any of the parties after a commitment decision has been made. And of course, there is no admission of guilt involved with a commitment application. Now, quickly, next slide, please. Quickly moving to settlement. As I said, settlement regime is pretty similarly designed in terms of procedure as to commitments, but the only difference is that there is, of course, first of all, it can be filed after the DG report has been published, which finds contravention by the particular party, and then once a settlement application has been filed, while it can be withdrawn, CCI will be free to rely on any information disclosed as part of the settlement application. And it also exposes party to any follow-on damages claims that might be filed by other parties, although there will be no admission of guilt. In this respect, one important point is that only informant gets access to files with respect to settlement application, and therefore for third parties to assert their claims in third party damages case could be slightly tricky. But over to you, Anisha.
That's a very interesting coverage you've done there, Pranjal. And I think with these new dispute resolution mechanisms that we have in place, at least I am personally very excited to see whether they are going to be used, or there are certain gaps which can still scare off parties from leveraging these very brand new mechanism. But before I turn to you, Anshuman, you've been patiently waiting and smiling. Your turn is going to come soon. But Pranjal, I have one question that has come. And the question is that it seems like the Excel crop judgment of the Supreme Court had put things in order with respect to imposition of penalties, and there were enough guidelines provided therein which could guide the commission. So why was there a requirement to have penalty guidelines? Do you think this materially moves the needle from what existed back in the day, or is this just a sign of the commission becoming much more matured and asserting a sort of a seat at the table of sorts?
It's a very good question, Anisha. And yeah, as I discussed previously, Excel Crop essentially curtailed CCI's power to impose penalty. So while CCI would have been happy with certain guidance on imposition of penalty, but Excel Crop essentially limited that power of CCI to impose penalty only with respect to relevant product under consideration, and that too up to a 10% of statutory limit. So what it essentially did was read into the law additional words which would mean that CCI could impose only up to 10% of relevant turnover as the penalty. What now the revised legislation, amended legislation, has done is that it has sort of restated the original law as it was previously, and now the penalties are back to being up to a 10% of the turnover of the entire enterprise. But of course, with the penalty guidelines in place now, there is guidance that when they come up with numbers, they will circumscribe those numbers within 30% of the relevant turnover of an entity. So that offers some good guidance for parties, and as well as it sort of ensures from a CCI standpoint that there is enough deterrence when they mete out penalties in their orders.
No, absolutely agree. And I think from the party's perspective, there is just more certainty and predictability to the process, because we all know that there have been some cases where decisions and penalties have been handed without much explanation. So I think that this really helps streamline the process that way as well. So turning to Anshuman, if you can just move to the next slide. Yeah. So we do know what we're going to talk about is very interesting. It's about dawn raids, and we do know that the commission, like all antitrust agencies, also wields this power or tool to crack down anti-competitive practices, particularly cartels, including, we've seen search and seize processes happening, even in case of leniency that Pranjal had sort of discussed, right? So dawn raids, I think, remain popular even in India, and just like an enforcement directorate or a tax department, commission, with the help of, or actually the director general, which is the fact-finding arm of the CCI, has been doing some raiding activity. We've read various news reports in the year gone by. So Anshuman, do you want to tell us what the dawn raid canvas looks like in the last year, and maybe give us a little bit of color on what you think the expectation for the coming year is?
Sure. Thanks, Anisha. Good to be back at our annual webinar here. Thanks to everybody for joining in. On the dawn raids bit, as at least publicly available information goes, there were no raids conducted in 2023. There was a bit of legislative change, as Pranjal, Manas, and Anisha have mentioned already in the last few minutes, which kept the commission busy. Investigations were not as active, as Pranjal also mentioned earlier, on the basis of which there were not too many raids which have happened in the last 2 years, but there has been an upheaval at the Director General's office as well. In January of 2024, we did see a new DG take office. This gentleman has been previously with the DG's office as well, so he comes with a fair bit of experience, comes with a fair bit of understanding of the law itself and the procedures as well. And that definitely will help the DG's office in conducting investigations going forward. Just before the end of the year, we did see one set of dawn raids come up with respect to global alcohol beverage companies in India. There were two companies which faced dawn raids as public reports, and these were in two separate cases and two separate investigations which are ongoing. at the same time. So December did see a little bit of activity, which perhaps leads us to believe that in 2025 as well, we perhaps will see more action from the DG, and raids will continue to be used as an effective and strong tool for detection of conduct-based activities as well. So 2025 does seem promising from an investigations perspective, and hopefully we will perhaps see the DG pick up its powers as well and use this fairly effectively.
Yes. Thanks, Anshuman. And I think there is, with respect to dawn raids, historically we've seen that this is being used only for busting cartels or collecting evidence in cartel cases. But more recently, we have seen that the Commission in vertical restraint cases has also not shied away from using this power wherever there was suspicion that there is some sort of suppression of information or incomplete information was being given. So, on that note, one of the questions that we have from the audience here is to understand any, if there was one practical tip that you want to give to everyone to prepare for a dawn raid, what would it be? Yeah, so over to you.
So we have over the years in India and globally as well seen raids happen across sectors. So it's not that certain sectors you will see dawn raids, and then certain sectors it's highly unlikely that you will. Uh, of course, there are sectors which are perennially under investigation, or there is high susceptibility of investigations being conducted in particular sectors. But leaving that aside, I think it's important for all corporates today to have an effective dawn raid manual. Having a good compliance policy is essential. We have seen and assisted our clients with a number of dawn raid manuals as well, which sort of pull out the fact as to how different people across the entire chain in the company should operate and conduct themselves during the raid itself. What should be asked for? What should people be mindful of? And starting practically from the security guard at the entrance of the office, the receptionist, and of course whoever specifically is being asked for by the commission or the DG's office when they do come in for such an investigation. So there is a particular way that you should be behaving, you should be operating during a raid itself. I think it's essential that companies prep themselves for such raids, and that is something that we have seen over the last few years. More and more companies prep themselves for. It's a definitely a fantastic good practice to follow. It's something from a compliance perspective which makes immense sense, and we have been helping a bunch of clients with that in the last couple of years as well.
That's very comprehensive. Thanks for that, Anshuman. If you can just go to the next slide, please. The next slide is again, Anshuman, I'll again turn to you to cover this. We did discuss initially that there was comparatively lesser enforcement activity, but at the same time, we've seen a lot of action, we've seen a lot of tech investigations, and we've seen a lot of parties heading and knocking the doors of the constitutional court on various matters. So I think from a practical perspective, it'll be good for the audience to have an overview of what's going on the enforcement side of things, and how, any particular takeaways that you have from this very fancy and circular activity heat map that we have here.
So, just to give a little snapshot of what all we saw through the year and going again chronologically, as Anisha mentioned, of course, tech found a place of prominence as it has been finding practically with competition regulators worldwide. So the CCI is not doing anything really different. It's following in the same steps that a number of global regulators have been following as well. So in June, of course, starting off with a non-tech case was a case where MRF approached the Madras High Court to quash its CCI's order, which converted MRF from a third party to an opposite party without any prior notice. So MRF did file a writ petition with the Madras High Court challenging this conversion. There were proceedings which were started by the CCI against another tire manufacturing company, a competitor of MRF, and MRF was required to provide certain information as part of that investigation. And subsequently, the parties who had assisted the commission in its investigation, perhaps as third parties, were converted to opposite parties. And when that happened, it was not really informed. MRF was not informed about this change. MRF got to know about it upon an inspection that it conducted of the documents in the commission's possession, and approached the High Court on that basis. And the High Court, of course, struck this down and quashed the CCI's order of conversion. The High Court actually said very clearly that an entity is entitled to know the status under which its presence and participation is sought in statutory proceedings. So it sort of came down in the commission for the opaqueness and the lack of transparency in this. Subsequently, then in August, the next interesting case which came up on the enforcement side was news reports regarding the DG's office submitting its report with the CCI in case of an investigation that it was conducting against Apple for abuse of dominance. This was an App Store's policies case, which is currently still ongoing. In this particular case, they did send across a non-confidential version of the report to the third parties as well. The DG's report unfortunately contained information which had commercially sensitive information of Apple, which led to the CCI, in fact, actually recalling the report as well. So that case is currently ongoing as well. In August, actually, we heard a fair bit of activity, and of course, in September and October as well, as you would see on the next slide. There was considerable activity in the case involving Amazon and Flipkart, which are two large marketplaces in India, online marketplaces, where there was an investigation being conducted regarding preferential treatment being given to certain sellers. In this case, the DG again found certain actions being taken by these entities to be in violation of the Competition Act. A number of the sellers, in fact, actually approached various high courts in the country for again conversion of such parties from third parties to opposite parties. The Karnataka High Court, along with a bunch of other high courts as well, did grant interim stay, but the CCI did go ahead and seek the prayer that these petitions from various high courts should be moved to either the Supreme Court or to the Delhi High Court. In fact, actually earlier this month, the Supreme Court has actually held that all such petitions would be moved to the Karnataka High Court. So there's one High Court which is taking direction, which will give directions going forward. In October, we saw the first major penalty of the Commission for the year, which was, and in fact, actually the only major penalty of the Commission for the year, which was in the case involving Meta's involving Meta, where the WhatsApp take it or leave it policy was penalized against. This case is currently under appeal, so we expect it to be heard by the NCLAT this month as well. Subsequently, we found the DG pushing its report out vis-a-vis actions involving Zomato and Swiggy and their exclusivity arrangements. This is a case involving the National Restaurants Association of India, which had filed a complaint against Zomato and Swiggy, which are large delivery services from restaurants. And in this case, again, the case is currently ongoing. It's still pending with the CCI, and we expect a final order in this hopefully this year as well. In December, finally, we came across news reports where the settlement regime, which Pranjal very helpfully explained a little while back, appears to be in action. Google appears to have offered to settle one of its cases involving Android smart TVs. So hopefully we should hear on that as well during this year in the first half is most likely. So this gives a little snapshot of what all we saw in the last year. And again, of course, happy to take questions later on.
Thanks, I think that's again a very comprehensive snapshot of what's been going on the enforcement side of things. Now, pivoting from here to the land of merger control, and to some extent, it's sort of staying with the theme of tech and digital space being a priority area for the commission. We have seen the deal value threshold, which has come about, and it sort of, can you please move to the next slide? Has created quite a bit of stir, and there's while the law is already come out with the legislative guidance on what are the cases that applies to, there are still certain ambiguities which will get fleshed out and thrashed out in the coming months, because technically the law is still very, very new and at its infancy. But again, just like how we did for the enforcement landscape, a quick snapshot of what's going on in the line of merger control. I think CCI has had its plate full with the deal value thresholds coming in. There are higher number of filings, and of course that is combined with generally the bullish deal activity that we've seen in India. Ticket sizes of deals is becoming much more pricier, and therefore I think it's rightfully so that the merger division at the CCI has had their plate full. So just to go through these statistics, I think in the last year we've seen a total number of 126 transactions being notified to the commission. And most of these were approved within 60 days. So the average number was 57 days for the approval timeline, and these are calendar days. The number of green channels is 20 for the last calendar year, and if you again contrast it with the previous years, and again one of the speakers is going to throw more light on this, we believe that this number has shrunk compared to previous years, where green channel was much more sought after and much more popular, and there we speculate that there are good reasons for the number to have dipped. But interestingly, after 10 September 2024, which is the date on which the deal value thresholds got implemented, we have seen 6 transactions being notified under this new threshold. And there is one of the questions in the chat box, but we've not seen any really true tech or digital deal being notified under that. So anyway, the deal value threshold is a sector agnostic thresholds, and we can see that a lot of non-tech deals are also getting caught under this new jurisdictional threshold to that extent. Financial sponsor deals was something that was very, very prominent in the filings made before the CCI. So out of the total kitty, 65 deals, which is almost half the number, a little less than half the number was notified, was financial sponsor deals. Strategic deals was 61. We had a few conditional approvals. 2 strategic deals had conditional approvals, and one of the financial sponsor deals that we saw in the private equity space was conditionally approved. But interestingly, all of these conditional approvals were also approved in phase 1. So there was no in-depth investigation or phase 2 investigations, including the Reliance Disney strategic joint venture that happened, where there were a number of divestments as well as behavioral commitments that the parties had given to get the deal approved. Like I said, green channel utilization has comparatively been lower. Whether the trend is going to continue is something that I leave for the speakers to answer. But with that, I'm going to again remain with Anshuman actually, and I would like him to explain what the merger control changes have been, and how that has changed even our lives as advisors, competition law advisors. Next slide, please.
Thanks, Anisha. So as you mentioned, 126 filings last year, which of course is a record if I understand correctly, in terms of the number being filed in a particular year. So which definitely is evidence of the fact that transactional activity has been at an all-time high, at least at the commission. We are seeing a large number of transactions being notified. Again, the changes which we see here on the screen practically got implemented only in the middle of September. So I'm not so sure that a lot of these changes would have had a significant impact this year, at least on the number of transactions notified. But that's something I think we'll be able to see much better at the end of this year. So hopefully the audience tuning in next year, same time, we'll have an answer on that at that point in time. But coming to the changes that we saw, and of course, very significant ones. The first one, of course, being the introduction of a deal value threshold. So, India now is part of a small set of countries worldwide which does have a deal value threshold. We are, of course, inspired to a certain extent by the law in Germany and Austria, and of course, the US also has a deal value threshold in place too. So, we now have a deal value threshold where the deal consideration being above 20 billion rupees, which is 2,000 crores, or if you convert it to USD, roughly about 235 odd million USD, such a transaction would breach the deal value threshold. However, there are certain conditions post this as well, which will be required to be met for the deal to be notified. So, going by the fact the target has to have substantial business operations, and the rules do specify what they mean by substantial business operations as well. They have uh, very clearly laid out the fact as to how substantial business operations would be considered in terms of digital markets, in terms of non-digital markets as well, and that would be an interesting way to see how transactions get notified to the commission going forward. As one of the questions has come up, there have been a number of deals in non-tech spaces which have been notified. We've seen transactions in, for example, banking get notified as well. The intention, of course, originally was to use deal value threshold for tech transactions, but the law itself is sector agnostic, as Anisha mentioned. We do see transactions which are non-tech being notified through this route as well. We do see maybe a little bit of change in terms of number of filings and a slight increase, but we do expect the increase from deal value to be offset by the fact that now export turnovers are to be removed from the for the from the threshold analysis as well. So we might see a little drop on that side. Which sort of brings me to the next point as well. Target exemption thresholds have been expanded. We have seen this to be routinely expanded and increased. And this is again no change. So now it's been increased to 450 crore in Indian rupees and 1250 crores in terms of turnover. Uh, and again, we have also seen the notification thresholds provided under the Competition Act itself being increased substantially. We see a 25% increase in the numbers. And yes, business operations does lead to revenue from India as well. There is revenue as a metric under the deal value threshold, but there is also number of users, etc. So depending on the sector in which the target is, the metric might be slightly different. Another important change which was brought about and after a fair bit of discussion over a number of years was the carve out for open market purchases. We still haven't seen this getting used before the commission since September, but now if there is an open market acquisition being done which requires an approval from the commission, that initial acquisition can be done and then a post facto filing can be made with the commission as well, which sort of helps you lock in pricing. That is something which was not allowed previously. There have been cases where the commission did, in fact, actually impose gun jumping penalties as well. In such instances, hopefully that will not be the case going forward. Next slide, please. Again, in terms of exemptions from filing itself, there has been a simplification of what the exemptions actually are. There is an ordinary course of business exemption which has always been there. It's now been limited to acquisitions by underwriters, stockbrokers, and mutual funds, which gives it a lot more clarity. There is, of course, increased clarity for minority investments below 25% as well. So sub 25% acquisitions are exempt if there is no control, board representation, or commercially sensitive information access being granted or gained through such an acquisition. In the event it's a sub 10% acquisition, then even if there are overlaps, that would not really be considered. So this is something which has been clarified by the commission because there were a number of rulings over the years which led to a bit of confusion in what the stand actually was. The law now is absolutely and very clear as to what the position should be when minority acquisitions are being considered. The introduction of the commercially sensitive information uh, point is something which is new. This wasn't there previously. I think in this year, of course, we should get some clarity from the commission as to what all they believe CSI would be. Of course, there is some basic information that we all obviously know as to what would be commercially sensitive information, but the expanse and remit of that is something which the commission should be able to clear through a few case laws this year as well, unless we do see some clarity in the form of FAQs. Uh, Incremental acquisitions have been simplified as well. There are certain exemptions available from 0 to 25%, if you're acquiring up to 5%, and again between 25 to 50 and 50 to 100 as well. But again, there should be no change in the quality of control that exists. I'm coming to the last two, and the second last one being the one on demergers. This is something which was informally already exempt. It's sort of been formalized as part of the exemption rules now. So demergers which lead to mirror shareholding are now exempt formally under the exemption rules themselves. Previously, we had conducted a bunch of pre-filing consultations on a case-specific basis with the commission, where the commission had granted us approvals, but there have been a number of cases where such transactions were notified as well. So this now clarifies and settles the position completely. Coming to the last point on timelines, which I think is one of the most important aspects when it comes to merger control, and is a key consideration. Earlier, phase one approvals were to be granted in 30 calendar days, but in 30 working days. But now that the timeline has been changed to 30 calendar days, we don't expect this to change drastically in terms of actual timelines on the ground. We do expect transactions to get approved within about 30 to 45 days, generally, depending on the complexity of the case itself. The outer timeline, of course, has also been reduced from 210 days to 150 days. So this is a set of changes that we have seen come up in September of this year. Last year, I'm sorry. Back to you, Nisha.
Thanks, Anshuman. I think a number of changes, some good, some yet to be tested. But when we're talking about reforms and change, I think it'll be an amiss if we don't discuss the digital competition law bill, which we already have in place. If you can just go to the next slide, please. Um, again, tech as a theme in antitrust conferences across the world and generally is something that everybody has been grappling with, all regulators. And in India also, there have been a number of cases. Sorry, we're going to just maybe step back and cover this aspect of gun jumping first. This is an important one. And Pranjal, are you going to tell us what we have on this slide right now? There have been some penalties and talks about Green Channel.
Yeah, sure. So in the last year, there has been only one case on gun jumping where a domestic private equity player has been penalized. And we have seen that penalty come through in Green Channel. We have spoken about this in the past as well. And in fact, in terms of numbers also, we do see a slide in the number of Green Channel notifications being filed. And that's primarily driven by, the CCI's very strict stance on looking at horizontal, vertical, and complementary overlaps. So in this instance, for example, the CCI was not convinced that there were no overlaps between the parties, even though a pre-filing consultation was conducted in this case. But ultimately, because these are questions of interpretation, it can move either way when the CCI or a different case stream of CCI applies its mind from a fresh lens. So from that point of view, we had one penalty of 1 million. So that's also important to note that while CCI has been imposing certain gun jumping penalties in Green Channel cases, but it's been mindful to not impose very high penalties. But nonetheless, the risks are too high for parties to opt for green channel where they cannot be completely sure that they can opt for the green channel. So and this is the second instance. The first instance was obviously in the last year, where again, in a similar scenario, parties were not able to uh, you know benefit from their pre-filing consultation and the view given there. And ultimately, because of interpretational room with respect to what amounts to horizontal, vertical, or complementary overlaps, the CCI ended up penalizing them for having used the green channel route incorrectly. Uh, so yeah, that's about it on the in the gun jumping arena from the last year. Not much developments, but hopefully it stays that way as well.
Yes, yes. No, thanks for that. And I think this is one of the major reasons which has driven or resulted in a dip in the number of filings, because CCI is more looking at the black letter of the law and what it says, as opposed to being more purposive in its interpretation and being lenient, with when it comes to green channel. So now we shall move on to the segment on digital competition law. Next slide, please. We do have a few questions in the chat window, but I'm also mindful of time, so I just want to make sure that we are covering all our slides. So on digital competition law, like I was saying earlier, we do have, so again, the law is, we do have a draft bill in place. There was a committee that was set up, and there are certain elements which are very, very distinctive for the Indian law. It is under deliberation, it is under consultation right now, and this is designed to be an ex ante law, which will have certain rules of conduct and engagement that certain pre-identified entities will have to follow. So Pranjal here is going to demystify very quickly what the journey of this bill has been, and at the stage at which we are, the draft bill that we have today, what are maybe the top key things to look out for that can have a bearing on your business.
Yes, thanks, Alicia. I will be quick here, mindful of the time, but essentially, digital competition gathered a lot of steam by the end of 2023, and then coming to the next year, which is 24, the bill was released. It was open for stakeholder consultation, but I think the process is slightly derailed at the moment, primarily because the committee usefully also came up with a draft of the bill, and I think at a larger level, the industry is having a hard time to digest the draft that the committee has come up with. There are a lot of deliberations, there are a lot of discussions happening on it. In fact, there are suggestions from some quarters that we should go back to where we were. We don't even need a digital competition law at this stage. So there are different views floating around in the market right now, and government is very circumspective before it introduces any definite law in this direction. So hopefully we will have some more clarity on this coming into 2025. But yes, during this process, as you can see from the slides as well, there were discussions across ministries. So METI, for example, facilitated a discussion on draft digital competition bill, which was well attended by various industry participants, and strong points were raised on how digital competition will, in the current form, may not be suitable for the country, and it appears that METI might have had a different point of view on digital competition bill. So ultimately, it all hangs in balance right now, and it remains to be seen which way, in which way direction of digital competition moves. Uh, Going to the next slide, please. Yeah, so just to quickly discuss some of the nuts and bolts of the digital competition bill itself, while some of you might have a little bit of idea of how the legislation has been designed. So the bill identifies 10 core digital services, and first of all, the identification of the digital services themselves have been subject to a lot of heated debates. For example, one of the core digital services is cloud services, uh, and there's a lot of noise that there haven't been any cases before the commission so far in cloud services market, and therefore including such a service within the ambit is slightly an overkill. But will this obviously this is a draft bill and it can undergo further changes as well. In amongst the core digital services, we have a catch-all kind of residuary digital services that has been defined in the bill. Again, it has invited a lot of flack because it's very, very wide, and any form of digital services offered through a platform will practically be included within the definition of what amounts to core digital services. Then the bill provides the criteria for designation of a systemically significant digital intermediate enterprise, and the bill and this is one area which has got the most attention from stakeholders, primarily because the thresholds are considered to be too low. For example, to meet quantitative criteria for an Indian enterprise, one needs to have turnover of over 4,000 crores, which is roughly around $350 million. And if your turnover is greater than that, then you qualify the quantitative threshold so far as the financial strength is concerned. And in addition, we have a user test, again, where the thresholds are very low. For example, again, there the number of business users subscribed or registered should be only 10,000, and number of end users could be as low as only 100,000. So those are very low thresholds, and this is one area which has got the most attention, and there is huge demand for increasing the thresholds because by some estimates, I think one of the independent bodies conducted some research, and it appears that probably up to 20 entities, Indian entities, could also become SSDs going by these standards. Again, as how the mechanism of the law works is that all the entities which are identified as SSDs are required to first of all self-assess whether they are whether they are to be designated. If they are once designated, they are then obligated to fulfill a set of obligations that have been laid down in very wide terms in the law. But importantly, these ex ante obligations will then be refined on the basis of regulations that the CCI will come up with. So by regulation, CCI can come up with differential obligations for different entities that are identified as SSDs. So this will give a little bit of a room to the CCI and somewhat a relief to prospective SSD, that they might not have to be obligated to comply with all sets of obligations that you see, and you can have some certain tailor-made obligations specific to a particular scenario. In terms of the penalties are pretty similar to what you see in the existing Competition Act, that is 10% of global turnover, up to 10% of global turnover. Then the draft bill also allows for a stage of DG investigation for contravention for investigating into contravention. But mind you, here the DG's role will be slightly limited. It will not go into the questions of whether the party has a dominant position, whether it is SSD, etc. It will only have a very limited role of investigating whether there has been a infringement of the obligations, and in that sense, the DG's role would be limited and also perhaps faster. And lastly, one important point to discuss before I end is interplay between Competition Act and the draft Digital Competition Bill. This is again a sort of a area of concern for many stakeholders, because these two legislations can practically run in parallel, and as a result, while an entity can face investigation under the new DCB, it could also face a traditional investigation under the existing Competition Act. And in that sense, a party could end up being subjected to a double whammy and double penalties in that sense. And there does not seem to be any bar in the law, in the draft law that we see, to prevent that. So that is something that has to be looked into as well. Over to you, Anisha.
Yeah, no, thanks, Pranchal. I think definitely I feel there's a room for a lot of refinement in the law. And with the number of laws and regulations that we are seeing to rein in technology, I think, personally, digital competition bill also needs to wait and watch what is the approach that the government is taking with respect to other regulations, and then come up with something which works best for India in light of those law and coexist harmoniously, because we don't want to force. There are enough and more with the CCI and other sectoral regulators. So with that, I'm going to move on to the last and final segment of our webinar. Next slide, please. Which is, we've seen and we've heard what 2024 was like. There are lots of learnings, lots of takeaways. There are some trends that are emerging that we think which we expect to continue to sort of spill over in 2025. So in terms of what we predict the enforcement landscape to look like, we do believe that the focus on tech will remain. There are a flurry of cases which are already under investigation or at various high courts, as Anshuman had explained very lucidly. But we do believe that because of all of the heavy caseload that the number of cases that the commission is seeing, there are more and more entities who are getting encouraged and becoming more confident to approach the commission. So we do believe that all of this activity is going to lead to more of a networks effect to bring other people also to complain against large tech companies. Second is on commitments. So Pranjal did mention, and Anshuman also sort of alluded to that Google has already looked at a settlements mechanism for its Android TV smartphone investigation. So similarly, we feel that settlements is something with a much more advanced stage, but commitments is something that may be a much more attractive proposition for parties that are being investigated, to avoid long drawn investigations and to also settle something quickly with the blessings of the commission, without having to go through that rigmarole and address those competitive harms issues at a nascent stage. So we do think that commitment holds some promise, and more parties potentially could explore this option if it works for them. Third is on invocation of writ jurisdictions in high court and high profile matters, and we've deliberately used the expression high profile matters because like I mentioned in the beginning, in a lot of cases we do find that processes at the commission have become streamlined and they are being mindful of principles of natural justice when they are adjudicating. But certainly in a large matters which involves a lot of parties or stakes are high, parties do want to do show an inclination to look at what other legal remedies they have to sort of quash the CCI proceedings or find grounds to assert their rights under the Indian Constitution. So we do think that given the stage those investigations are at, we do believe that will also continue in this year. Traditional sector focus, as we said in the beginning, we did see activity in Alcobev. We do believe that some of the favorite sectors of the commission, where there is, generally the structure of the market is conducive to catalyzations, or there is, there is an oligopoly, their activity will continue. And generally, again, just going back to what we have said earlier, the performance of the commission at appellate tribunals has been good. So I think the institutional focus of the commission would be to sort of advocate that all of its orders are upheld. Don Raids Anshuman has already stated that with the new rules being implemented, we do expect that in cases where there is a need, raids will be conducted, and generally that is also consistent with what we are seeing in our country overall, with the enforcement directorate also becoming fairly active, and also we do know that there is a lot of inter-regulatory dialogue also which is happening in cases where there are search and seizure operations for coordinated activity. With that, next slide please. On merger control, again, merger control, we believe that deal value threshold will bring into for quite a few deals. Next slide, please. Um, so deal value threshold, and which will again include both tech and non-tech. Personally, I feel more non-tech than tech, but we'll see. Time will tell that. Green channel we've discussed enough about, but green channel, I think the takeaway is be more cautious. It having a green channel and having no material impact on competition does not guarantee you access and eligibility for green channel. I think that's been the very clear messaging of the commission over the last 2 years. So be cautious, and please, even though it is not mandatory, please engage in consultations with the CCI is generally what our advice has been. Expect more request for information. Again, this is a consequence of shorter approval timelines that the commission has. So we are in our live matters seeing that there are more RFIs, requests for information, to stop the clocks. And in complex cases where there could be issues or concerns, or there are questions as to the market definition, it is recommended that you do again pre-notification consultation to prevent any invalidation of notices. Extensive scrutiny, while it will continue, is and in some sectors which happen to be more complex or concentrated, we do, I think the good news here is that we do think that the commission is also aligned, and they would also prefer that in cases which do pose risks of competitive harm, they close the process in phase 1 itself instead of phase 2. And I think that the fact that after 2018 we have not seen any full-fledged phase 2 indicates that the commission is also equipped to handle these large cases in phase 1, and B is generally inclined from a timing perspective to move things forward and resolve issues quickly in phase 1 rather than taking a dip in phase 2. And I think generally speaking, just in terms of process, because of this shortened timeline, we do see that commission is preferring to go to a faceless system where there is lesser direct or informal interaction with case teams. But again, this is something that we've experienced in the last few months. But hopefully, after receiving some feedback, the commission may go back to being a little more direct and informal in its communication. In terms of applicability of exemptions, also similar to Green Channel, there is please expect that the commission is going to take conservative views. If your transaction is not fitting squarely within the explicit verbiage used in the regulation, in the exemption, it is unlikely that the CCI will provide an exemption for you, because their hands are going to be tied. So this is what we think this year is going to look like. And we have reached the end of, we've finished our 90 minutes. Thank you so much for all of your questions. I personally thought that the discussions were very, very insightful, and the questions were also very sort of it showed active participation. So I do believe that everybody thought that this was valuable, and it also sort of leads and gave you enough indication about the future direction in which Indian competition law is headed. Thank you everyone for attending this. We enjoyed bringing this to you. We'll bring this to you again. So please give us that piece of encouragement, and we hope to see you again next year. Thank you so much, and bye bye. Have a great day ahead.